So thank you for your cooperation all the while. We'll be starting very soon.
Dr. Sachin, we can start.
Yes, sir. Respected speakers for today's lecture, Honorable Advocate Tariq Khan, Principal Associate, Dispute Resolution, Advani and Company, New Delhi. The Honorable Director of Symbiosis Law School, Dr.sukhvindersinghdari, sir. The esteemed participants from the institutions across the country, respected faculty members of Symbiosis Law School, Nagpur, and dear learner friends, not only from Symbiosis, but from institutes across the country. I, Sachin Tripathi, the moderator for the day, welcome you all this afternoon to yet another component of our guest lecture series on a very important topic of importance and future of arbitration laws in India. Friend, in today's age of globalization, arbitration has gained tremendous significance as a leading method of dispute resolution, both nationally and internationally. Friends, the three key factors of speed, flexibility, and confidentiality makes arbitration a preferred dispute resolution mechanism. Some important developments in India, including the amendment to the Arbitration Act in 2019, the judgment of Supreme Court in Bar Council of India versus A.K. Baja and others, have paved a suitable environment for strengthening the process of arbitration, not only domestically, but internationally as well. Friends, there are certain loopholes and shortcomings in an arbitration environment in India. Nonetheless, it remains a preferred dispute resolution mechanism. With this small piece of introduction, first of all, I welcome or I invite the Honorable Director, Dr. Sukhvindersinghdari, sir, Director, Symbiosis Law School, Nagpur, to give his welcome address.
Very good afternoon, Advocate Tariq Ahmed Khan, sir. I welcome you to this webinar series. Thank you very much for accepting our invitation and give your valuable time to us in spite of your busy schedule. Sir, at Symbiosis Law School Nagpur, which we established last year, we are planning to open a center or establish one center for arbitration. So many of my students are interested in this area. So we thought, why not to start with first the webinar series or some interaction with some expert. So I really follow you. You are an expert in this area, and you are delivering many lectures across the country on this area. So you were the first preference for us when I was interacting with Dr. Shilpa, whom to invite. So you were very kind to accept the invitation. Thank you so much for that, sir. And I would also like to share that we got a very good response across the country for registration for this webinar. This has happened for the first time. So I welcome all the participants across the country, those who are part of this seminar, and also my students of Symbiosis Law School, Nagpur. With this, I request you, sir, to also support us and be in touch with us about this new center which we are planning and share your expertise and knowledge with us. Thank you so much for that. And I welcome each one of you once again. Over to you, Dr. Sachin.
Yeah, thank you so much, sir, for your welcome address. Friends, I am indeed honored and very happy to introduce to the gathering our prominent speaker for today's lecture, Advocate Tariq Khan. Friends, it will be a very difficult exercise for me to justify his illustrious profession and career in a short span of time, but I will try to do justice with that. Friends, Advocate Khan graduated from Faculty of Law, Jamia Millia Islamia, with BA LLB honors degree and with merit. During his illustrious career as a student, he was the coordinator of Internship and Placement Committee and convener of Literary and Debating Society. Friends, Advocate Khan has a rich teaching and professional experience. His prominent engagement as a teacher includes delivering guest lectures at cherished institutions like Indian Law Institute, Lloyd Law College, Greater Noida, various bar associations like Dwarka and Saket Court Bar Association, New Delhi, Indian Railway Institute of Logistics and Materials Management and International Chamber of Commerce, New Delhi, Manav Rachna Society, Faridabad, then Lloyd's ADR Center, and many more. He has a very illustrious professional career as well. And to his credit, he has the distinction of representing various national and multinational companies. To name a few, he represented a public sector undertaking in a multi-million-dollar dispute in International Court of Arbitration arising out of an illegal termination of contract for setting up of a blast furnace. He represented a US-based seismic imaging service provider for enforcement of foreign award in India. He also represented a leading renewable energy solutions provider in an arbitration proceedings. Friends, the list is long and I can continue. Friends, Advocate Khan is a prolific writer also. To his credit, he has authored a book on the Rise, published by Universal Law Publishing House. And I am very proud to mention that for this, he featured in Fortune 500 magazine 2017-18 special issue for this authorship. He has several other publications like Drafting an Effective Arbitration Clause, Virtual Hearings and Future of Justice, The Art of Cross-Examination, 25 Important Judgments in Arbitrations, and many more. Friends, he is a cherished invitee in various webinars and panel discussions, not only at national but international level as well. He has various honors and awards to his credit. Very prominently, he has been appointed by the Arbitral Tribunal as an administrative secretary in an international arbitration conducted under the SIAC Institute rules. He has been interviewed by Indian Journal of Law and Public Policy and Lex ADR on future of institutional arbitration in India. Friends, he has also been a judge in various national and international moot court competitions as well. So let me have the honor and privilege of inviting Advocate Tariq Khan to deliver a very important lecture on the importance and future of arbitration in India. So I request you, sir, to kindly take over and deliver the address. Sir, you have to unmute your mic, sir.
Yeah, now I have to mute.
Thank you, sir.
I'm not used to Google Meet. Mostly all my webinars I've done on Zoom. So I'm really sorry. Thank you. At the outset, I'd like to thank Mr. Sachin for such a lovely introduction. And thank you, Dr. Sukhvinder, the head of the department, for such an excellent opportunity. It's my pleasure, sir, to be here and I'll be more than happy to be associated with your college and to help the students in whatever way I can. And I'd also like to thank Dr. Shilpa for being very supportive and for the excellent coordination that she has done. Thank you, all my friends who are present here today to have a discussion on the importance of arbitration in India and the future of arbitration. I have been told that, I hope I'm not incorrect in assuming that most of you are the first year students, because I think your college has, only started recently. So this is perhaps the first batch. So most of you, I'm assuming, would be first year students. And I'd like to keep today's discussion interactive. So if you have any doubt, any question, whether it is related to arbitration or it is not related to arbitration, if it's related to college life or how to go about it, you please feel free to ask me any question that you want. I'll be more than happy to answer your questions, because the idea is to make it interaction. So you can keep typing in the chat box just in case you have any question, or we can have a question answer session in the end. Okay, so before I begin with the discussion, I'd like to first highlight what is arbitration, because a lot of you may not be knowing what arbitration is all about, though it has become very popular recently. And I'd like to tell you, I'll share with you my experience when I was in college. So when I was in Jamia, there was no separate subject of arbitration as such. And I did not get any opportunity to read arbitration as a subject. And when I was looking for jobs, that's when I applied in a law firm called Advani and Company. And by that time, I had zero idea about arbitration, frankly. So I'll be true to you. It's not the case that from college onwards, since day one, I was very confident that I'll be doing arbitration or practicing dispute resolution. So, I think arbitration chose me, and I ended up doing a job in a law firm which was doing arbitration. But when I started doing arbitration matters, I realized that it is a very, very interesting field, and it's a very, very wide and vast area to practice. The term arbitration, basically arbitration is a alternative method for dispute resolution. Like there are various other methods. The most popular in India, though, of course, is litigation. We know that if a dispute arises between two parties, the common thing to do is to go to a court of law. But because there was too much of pendency of cases and courts were taking too much time solving disputes, and they were already overburdened, plus there was so many vacancies in judiciary, due to which it was felt that we must encourage other methods of dispute resolution, which includes arbitration, negotiation, mediation, conciliation, to name a few. Now, today we'll be only confined to arbitration because, in my view, it is the most popular choice for dispute resolution. And I'd like to quote Mr. Falius Nariman, the living legend of law. In a conference recently, he said that the future of arbitration is bright because the future of litigation is not. The reason why he said so, because when you go to the court of law, you realize that if you're filing a case, then you do not know when it is going to get listed. There are too many technicalities in law. There are too many technicalities in filing. So the filing procedure itself is a task. So the procedure is the punishment. Today, if I have to file a petition, I have to first, there has to be a particular format which has to be followed. Then the registry will raise certain objections. And then my matter will perhaps be listed in a week's time or so. So, it's a lot of task, too many technicalities. Therefore, I feel that arbitration is a preferred method for practitioners also, for us, for youngsters, and for all of you in times to come. Because arbitration is very flexible. That is a very, very important factor why it is preferred over litigation. Because in a court of law, many people in fact say that courts are more about technicalities now than merits. Merits come later. Firstly, the technicalities. So due to the complex court procedure, it becomes very difficult to, in fact, get your matter listed, argue on merits. Another side, another counsel who is very experienced, if I'm appearing in a matter, may raise a technical objection on CPC, Code of Civil Procedure, or Evidence Act. But the beauty about arbitration is this, that if you read Section 19 of the Arbitration Act, it categorically states that Evidence Act and strict rules of CPC will not apply to arbitration proceedings. Now, what is an arbitration? Typically, I will tell you. So how it all starts. Assuming that you do not want to go to the court of law and you want your disputes to be resolved by arbitration. Now, how do you get into an arbitration? Because we all know what arbitration is, but we don't know how it all starts. So I'll take you step by step. And at any point of time, at any juncture, if you feel you have any question, I'll be more than happy to answer then and there. So when two parties are negotiating a contract, now it's very common for two entities to enter into any agreement. Then they realize that, look, disputes are inevitable. Disputes are bound to happen. And in case any dispute arise, then we will resolve it not by courts, but by arbitration. The reason why it is encouraged is because these MNCs, these commercial entities, do not want to go to the court of law because they know if they go to the court, their money will get stuck for years. Sometimes the hearing is being given in 6 months, 8 months, and sometimes the matters may take 10 years, 15 years. So they don't want their money to get stuck for that long. Therefore, they want an alternate setup where the dispute can be resolved conveniently, comfortably, expeditiously, and they get their money quick. So that's the whole idea about encouraging arbitration as a dispute resolution mechanism. So when two parties are negotiating a contract, they will be like, look, we want to resolve this dispute, if at all, tomorrow any dispute arise, through arbitration and not through courts. Now, what is arbitration typically? They will draft an arbitration clause in the agreement, because an agreement has many clauses like indemnity clause, payment clause, time period clause. Similarly, they will in the end put a clause called dispute resolution clause, which is arbitration clause. So parties will say that assuming that a dispute arises tomorrow between us, they will word the clause like this. Any dispute arising out of or in relation to the contract shall be resolved by a sole arbitrator as per the Arbitration Act 1996, and the seat of arbitration shall be Delhi. So, this is the typical language of the arbitration clause where parties says, look, tomorrow if disputes will arise, a sole arbitrator. So sole arbitrator is basically one arbitrator. So arbitrator in a way is at par with a judge. So in arbitration, there are arbitrators, they're not judges. In courts, there are judges. Now, who are these arbitrators? So mostly in India, the practice is that these arbitrators are retired judges or senior advocates and some lawyers. Now, recently, the rule is that any arbitrator must at least be 10 years into the practice. So that's the minimum age limit which has been prescribed under the 8th schedule, which has been introduced under the 2019 amendments to the Arbitration Act 1996. So an arbitrator can either be one, or there can be an arbitral tribunal of 3 members. So the number has to be always odd. It can never be even, because if there is an even number, then one person gives a decision against and one gives in favor. So dispute will again arise. Therefore, the number has to be mandatorily an odd number. So that's the role of arbitral tribunal. Now, how to appoint an arbitrator? So one step I have told you that you put an arbitration clause in the agreement wherein you say that if disputes will arise, we will resolve it by arbitration, and we will not be resolving it by the court of law. We will not be going to the court of law. So the idea is that tomorrow, if dispute arise, just in case, if there is an agreement between A and B, and A feels that B is not making payments to A, so A will invoke the arbitration clause. Now, what is invoking an arbitration clause? Invoking an arbitration clause basically means that you are going to start arbitration proceedings. You're going to take action against them. So you have to mandatorily send a notice invoking arbitration, which is like a legal notice, wherein you will tell them the dispute that has arisen between the parties, and you will say, I am invoking the arbitration clause, which is clause so and so, and this is under section 21 of the Arbitration Act. Now, the date on which the other party, that is B, receives the arbitration notice sent by your lawyer or by you, then that will be the date on which the arbitration proceedings will set to have been commenced. So always remember that the commencement date of arbitration will be when one party sends the notice invoking arbitration under section 21 and the other side receives it. That will be the crucial date. So now you send your arbitration notice to them, and they will of course not agree with the name you are suggesting to be the arbitrator, because you will say that I want to appoint Mr. X or Mr. Y as the arbitrator, and they will of course not be happy about it. They'll be like, no, we don't want this person to be appointed because he is not a neutral person. Eventually, parties will have to go under section 11, which is in the Arbitration Act, for appointment of arbitrator. So you file a section 11 petition before the High Court, because only the High Court is the concerned court for appointment of arbitrator in a case of a domestic arbitration. Now, this brings me to a question that arbitration can be of two types. One is it is a domestic arbitration, which is between two Indian parties. And the other is that there is an international commercial arbitration defined under section 2, which talks about an arbitration between when one party is a foreign party or there's an element of foreign party. So if it is an international commercial arbitration, that is one party is a foreign party, then the appointment of arbitrator can only be done by the Supreme Court. So in that, sorry, is there any question? Okay.
No, sir, you can proceed.
So under section 11 of the Arbitration Act, if it is a domestic arbitration, and then you will go to the High Court for appointment of the arbitrator. And if you want to get an arbitrator appointed in a international commercial arbitration, then you will have to go to the Supreme Court. Now, this is on the basis of the parties involved. Now, there is another type of arbitrations, which are ad hoc arbitration and institutional arbitration. Now, ad hoc arbitrations are where the arbitration is conducted by the parties themselves. They make all the arrangements. The arbitrator will decide all the procedural directions, and there is no institution involved. Whereas in an institutional arbitration, there is one institution which is taking care of all the procedure and all coordination. It makes it very convenient. For instance, in Delhi, we have an institution called Delhi International Arbitration Center. So when an arbitration is conducted under the aegis of an institution, then it becomes very convenient and very, very easy for parties, because the institution is supervising the whole arbitration. And the rules of the institution will govern the arbitration. So that is the reason why it's preferred that an institutional arbitration is always better than an ad hoc arbitration. So far as ad hoc arbitration and institutional arbitrations are concerned, if there's any question, please ask me. Okay, I have a question. Arindam is asking a question, Mr. Arindam Sareen. How is the sole arbitrator decided? Is it by the consent of both the parties? Arindam, very good question. If you read section 11 of the Arbitration Act, it says that parties will obviously, if parties have agreed that they want to appoint Mr. X as the arbitrator, then there's no dispute. That person will obviously be the arbitrator because both the parties consent. So the beauty about arbitration is that it talks about party autonomy, which means freedom of parties. So parties get to decide everything, how they want to go ahead with their arbitration, who will be the arbitrator, how will the dispute be resolved, what will be the procedure followed. All these things parties can decide. And dates can be chosen as per parties' convenience. The venue can be chosen as per parties' convenience. The good thing about arbitration is that Not like the courts where you have to go since morning and, spend your full day, wait for the whole day to get your matter listed or heard. Whereas in an arbitration proceeding, if parties want, because of course parties have the money, so they can book any nice venue. It can be a resort, it can be a club, it can be a five-star hotel or a normal hotel. So you can just do an arbitration proceeding anywhere. It is very, very informal in comparison to the court. You don't have to wear the black coat. You don't have to be, in a gown. You don't have to wear a band. You can wear a suit. You can wear a tie, and you can, of course, you have to be formally dressed up. But it's very, very informal setup in a way that, parties are conveniently sitting, comfortably sitting. It's a good setup, and the arbitrator is sitting there. In the middle of the hearings, we are having tea. We can have biscuits, and one party can argue the case comfortably, conveniently, for as long as the party wants. And the dates can be chosen as per the convenience of the parties. So generally what we do in arbitrations, especially in international arbitrations, we block 4 or 5 hearings at a stretch. So these are full day hearings. So the dispute gets over in these 5 days in the period of these 5 days, it gets argued at length. I'll come to this. So the question that you asked regarding the sole arbitrator, yes, parties can decide. And if the parties are not at consensus, there is a disagreement on the name of the arbitrator. Only in that scenario, parties will go to the court under Section 11. Now, Ms. Geetu has asked me a question. Geetu Sachidanand. Since the arbitration is said as an out-of-court settlement, why High Court or Supreme Court appoint an arbitrator? Now, that's a brilliant question, Geetu. That's correct. I mean, that's one issue which I feel is with arbitration. Now, to do away with this practice, the 2019 amendments have come up with a solution to this question. You're right. For appointment of arbitrator, then for challenging the award, I mean, due to these issues, you have to eventually go to the court. Then how is it out of court settlement? So therefore, if you look at the language of Section 5, I think 4 or 5 of the Arbitration Act, it says minimal court intervention, which means that unless it is provided in the Act, the courts will not interfere in any arbitration. So the Act tries to keep courts outside arbitration, but there are certain purposes like appointment of arbitrator, interim reliefs, and challenge to the award, appeals under the Act. They are done they are entertained by the court. You're right. But so far as the appointment of arbitrator is concerned, after the 2019 amendment, what the legislature has suggested is that there will be an Arbitration Council of India. An Arbitration Council of India will govern certain institutes. So the Delhi High Court and the Supreme Court will now determine certain institutes for appointment of arbitrators. So the applications will not be heard by the court. Those institutes will be appointing arbitrators. Okay, another question by Atharv I've got. Are there lawyers or only the parties are supposed to argue or resolve? Good question, Atharv. So in arbitration, it is exactly like the court. You engage a lawyer. The lawyer will present your case. You all may have seen Suits, Harvey Specter and Mike Ross. So yeah, it's like that kind of setup. It's a very fancy setup where parties go. They have counsels, a team of lawyers who do the filing, etc. The good thing about arbitration is that there are no formats. There are no formats to be followed. You can file your statement of claim like we do in moot courts. You can make it very nice with proper footnoting, etc. You present your case the way you want. So that's the good thing about arbitration. And lawyers are engaged. It is exactly like the court. You are engaging lawyers. The other side is engaging lawyer. And yes, if party wants to speak something, the parties can always take permission of the tribunal because it is a less formal setup. Okay, now the question from Mishti. Mishti is asking, can arbitration orders be challenged? Yes, Mishti, you need to see Section 37. Section 37 of the Arbitration Act talks about the appealable orders. So whatever is provided under Section 37, only those orders can be challenged. And the award, which is the final judgment of the arbitrator, it can be challenged under Section 34. Now, Nikita has asked me another question. Sir, if you're not satisfied with the arbitrator's award, can we move to the courts? Yes, Nikita Sharma, you're right. We can move to the court under Section 34. of the Arbitration Act, which talks about challenge to the award. Now, moving forward, so once you invoke your arbitration and you get an arbitrator appointed under Section 11, then the arbitrator takes over. So the arbitrator has to finish the arbitration within 1 year's time. So I was talking about the beauty of arbitration because today's topic is why arbitration is important. Because in a commercial world where we are living, where so many MNCs and companies are coming doing business, so they do not want to, they don't want their money to be stuck in courts forever. They want that if a dispute arises, which it will, we all know, when we are entering into a agreement with a party, we know that disputes are bound to happen. So they want that their money should be given back to them at the earliest and their disputes are resolved expeditiously. So the beauty about arbitration, which is rightly pointed by Mr. Sachin in his inaugural remarks, he said that speedy resolution of dispute. So India is one country which has now fixed a timeline. So practically the period of resolving arbitration is 1 year. So no court will give you this guarantee that, look, we will decide these disputes in 1 year's time. Whereas in arbitration, the endeavor is to finish the dispute, to resolve the dispute and pass an award within 1 year. Now this time period has slightly changed after the 2019 amendment because 1 year was not practically possible. So after the amendment of 2019, now the period is like this. First 6 months for completion of pleadings. Now what are pleadings? Pleadings are basically your written case, like the memorial that you file in moot courts. Pleadings will be a statement of claim filed by the claimant, then statement of defense filed by the defendant, the respondent, and then the rejoinder to the statement of defense by the claimant. So these are the pleadings. So for completion of pleadings, you get 6 months time and then 1 year's time for concluding the arbitration and passing an award. So in a way, now it is 1.5 years. This period is extendable to another 6 months by consent of parties, mutual consent of parties, which makes it 2 years at max. And if this period gets over, then parties will have to approach the court for another extension. So this is about the time period. So the way I am explaining about the time period being crucial, this makes arbitration beautiful and very, very important. And that's the first choice of dispute resolution because parties feel that my dispute will get resolved in 1.5 years or 2 years at best. So that is one reason why expeditious disposal of the dispute is making arbitration more attractive and as the first choice in the commercial world. So the other reason that I told you is party autonomy, which means that parties are in charge, parties decide what they want, parties are the bosses. So if you look at various sections of the Arbitration Act, many of them in fact start with the word unless otherwise agreed by the parties. Now, why do they say so? So it means that if parties have suggested or agreed otherwise, then the provisions of the act will not apply. So the consent of the parties is more important. It supersedes than the act itself in certain provisions. So that's why party autonomy is another beautiful feature. The parties can custom or alter or tailor their arbitration as per their own needs. That's another interesting feature. The third important feature is flexibility. Arbitration is very flexible. Strict rules of CPC and evidence, like I said, do not apply. There are less technicalities. So young lawyers like you and me, we can make a mark in arbitration because, I have not seen many, because, in the court, we may face a disadvantage. When we are appearing before a court, any lawyer who has spent like 30 years, 20 years in the profession would know more about the procedural aspects, the technical aspects, and may be able to take objection, which you may not have any clue about. Therefore, in arbitration, this disadvantage will not be there. Like I appear in matters independently against people who are very senior to me. But to be honest, we are all at par. Apart from the knowledge part, but procedurally, you will not face any hurdle. That's for sure. So that's another interesting feature about arbitration and why you should develop interest in arbitration. The reason why arbitration is becoming so popular in almost every contract, parties are putting arbitration clauses. That's another reason for you to choose arbitration as a career or perhaps develop interest in arbitration, because it's a very vast area of practice and it is not restricted to a particular kind of disputes. If you go into arbitration, so there are statutory arbitrations, then there are construction disputes, that's another vast field of arbitration, then maritime arbitration, energy disputes, oil and gas. So many kind of arbitration disputes are there. So you can, develop interest in a particular field also. So arbitration in itself is very wide, just like litigation. Now, moving to another aspect, why I feel that, okay, there are questions. Divya has asked me a question. Divya Nand is asking me, is it true that the arbitration agreement is valid even though the main contract is void? Arbitration agreement is totally independent of the contract. Yes, Divya, you're right. Arbitration clause, though it is a part of the main agreement, has its own existence. It is severable. It can be separated from the main contract, and that arbitration agreement will survive even the termination of the main contract. So if the contract is terminated, arbitration agreement will still survive because it is independent of the contract and it has its own separate identity. Now, Arya Kailabag has asked me a question. Sir, who takes the final judgment of the dispute resolution if really the dispute occurred in a very difficult confusions between the two arbitrators? Good question, Arya. So there is a panel of 3 arbitrators. Like I said, the number has to be an odd number. So the presiding arbitrator, so generally how it's done when it's a tribunal of 3 members, because that's what your question is, one arbitrator will be appointed by me, the other arbitrator will be appointed by the other side, and the neutral arbitrator will be decided either by the court or by these 2 arbitrators mutually. So if there is a dispute between 2 arbitrators on a point, then yes, whatever the presiding arbitrator says, it will be final. So the majority award is 2 members being on the same side. Whether the third one is dissenting, it doesn't matter. Okay, P. Rama Kalyan is asking me a question. Is jurisdiction considered in arbitration? Yes, jurisdiction is considered in arbitration. Section 16 of the Arbitration Act talks about competence. It's a very interesting doctrine of arbitration, which says that the arbitration is competent to decide or rule on its own jurisdiction. So if you are challenging the jurisdiction of the court, of the tribunal, you have to move an application under Section 16 of the Arbitration Act, and that will be decided by the arbitrator himself. Now, another question is by Snehil Soni. Snehil is asking, as arbitration is more of a commercial issue, so is that BBLLB is having more scope than BLLB? No, honestly, Snehil, I don't think it will make much difference because at the end of the day, as long as you have a law degree, what matters is that you have some exposure. What you can do in college is you can add up these courses. You can perhaps do internships, which with law firms or with lawyers who are doing arbitrations day and night, or you can do internships with institutes like Delhi International Arbitration Center, where you can see arbitration on a daily basis. And I think that's very important if you are trying to develop some kind of interest. The other thing that you can do is you can perhaps read articles, write articles on arbitration, keep yourself updated by reading latest judgments on arbitration. I think these are the things which are more important rather than BB, LLB, or LLB. It doesn't make much difference. Okay, another question by Jiyush. Jiyush is asking me, sir, does the law of limitation apply to arbitration proceedings? Yes, the law of limitation applies to the arbitration proceedings. The time period for filing a claim before the arbitrator is 3 years. So if a cause of action has arisen, you have only 3 years to file a case before the arbitrator, after which you cannot. Now, moving on, another interesting feature of arbitration is confidentiality. Why parties love going for arbitration, very rightly pointed by Mr. Sachin in his inaugural remarks, is that confidentiality is a key feature. So confidentiality means that whatever is happening in an arbitration will not be put in public knowledge, which means that if a dispute will arise between me and you, then we will resolve it sitting in a conference room or anywhere, like I told you, the venues, and nobody will get to know about it. In fact, the awards which are passed by the arbitrator are not in public, they are not available. So yeah, the question of Snehal is answered here. Snehal has asked, is arbitration award a precedent? So it cannot be a precedent because it is confidential and it cannot be used in another arbitration because parties like to keep their identity discreet. They don't want that public should get to know what disputes are happening. Because, I'll give you an example. If I am a company and public has invested a lot of money in my company, buying my shares, and if they get to know that I'm in a dispute of 4,000 crores, they may want to take their money back. They may think that what if this person lose? So I think in my view, this is the reason why parties do not want the public to know about it. Okay, Tanmay has asked me a question. Tanmay Sharma is asking, how is the legal cost and arbitrator fees dealt with in arbitration? Now, this is an interesting point. Tanmay wants to know as a lawyer how much he'll be able to charge when he is doing arbitrations. Okay, so the legal cost, so far as the fees of the lawyer is concerned, that is on you. You can charge any amount of money. Nobody is going to stop you. It depends on which lawyer are you engaging. But regarding the arbitrator fees, now there are guidelines. If you see Schedule 4 of the Arbitration Act, it has a slab that if a dispute is ranging from this amount to this amount, then the fees of arbitrator will be this much. So it gives a table, so you can check it from there. Shruti is asking me a question, who is going to give the final judgment on these disputes which are solved by arbitration? So Shruti, Khatri, the answer to this question is that the award of the arbitrator is generally binding and final. Parties get 90-day period to challenge that award. And the court under section 34 entertains such a challenge. And the grounds for challenge are very, very narrow. So the courts generally refrain from interfering with the arbitral award. So in 90% cases, there is no interference. Only in 10% cases, you will see that the courts are setting aside the arbitral awards. And if you are not happy with the decision of 34, then you go under section 37 for an appeal. And last option after that is Supreme Court SLP. So that is the end of all the appeals. So that is the final word. Nana is asking me a question. Nana Podar is saying, so where do we read the arbitration judgments if they are not available to public? Good question. Very good question. So Nana, what I meant was that arbitration awards are not available in public, but whenever an interesting issue relating the interpretation of the act arises, so that is when the courts pass judgment on these issues. So like I told you, there are section 9 applications which are filed in court for interim reliefs. Then there are section 11 judgments which are filed in court for appointment of arbitrator. Then 14, 15 for substitution of the arbitrator or termination of the arbitrator, the mandate of the arbitrator. Section 34 for challenging an award. Section 37, appeal under the arbitral award. So all these petitions are filed in the court and the court passes a judgment on this. So this in a way gives clarity to the act, and those are the judgments I meant that you should read. And if you want, I think there are certain articles on Bar and Bench, one of them written by me, one of 5 of them, wherein I have summarized all landmark judgments. You can read it if you want. It's called 50 Landmark Judgments on Arbitration. Pratiksha Priyadarshini has asked me another question. Can a lawyer switch to arbitration after practicing litigation for a considerable period of time? Yes, Pratiksha, the beauty about arbitration is, do not think that if you are doing arbitration, you can't do litigation. In fact, I, on a daily basis, have to go to the court as well as do arbitration. So when you get an arbitration matter, so you have to go in the court every day for that matter, like whenever required. It's like if you're an arbitration practitioner, you first have to get an arbitrator appointed from court. So you are doing litigation. You're filing a section 11. Then if you're challenging an award, you're filing a section 34. You're again attending court. If you are filing an appeal, you are filing a section 37. You're again going to the court. So arbitration and litigation in a way go hand in hand. So it's not that if you are practicing arbitration, you can't do litigation. And if you are only doing litigation, even then those skills will be used in arbitration, because at the end of the day, you have to argue the matters before the arbitrator. The only difference is that you are sitting and you are in a less formal setup. Now, Sakshi Vajera has asked me another question. What all traits do we need to build upon in case we want to go into the field of arbitration? Sakshi, all traits of a good lawyer are required. You need to present your case nicely. You should be good at drafting. You should be able to convince. You should have that convincing power, and you should have all the gift of gab, the oratory skills which are required. So I think it's same as being a good lawyer. Ishan Kishti is asking me a question regarding the activity related to the dispute. Does the arbitrator has the say to whether these activities should be put on stay? And if not, then isn't approaching the court making time consuming? So, Ishan, if you look at the language of Section 17, there are certain grounds which are mentioned where the arbitrator has all powers of the court to grant interim reliefs or interim injunction, etc., etc. And it is only when the tribunal does not have the power to do something that is when you go to the court. So the Act clearly says that minimum intervention of the court. And yes, once it goes to the court, it becomes time consuming. You are right. Shriyan Srivastav is asking me what are the validity requirements for an arbitration agreement. Shriyan, if you look at Section 7 of the Arbitration Act, it defines what is a valid arbitration agreement. It has to be signed. It has to be between both the parties. It must talk about consent of the parties. There should be key components. Who is going to be the arbitrator? The parties should give their clear intention that they want their dispute to be resolved by arbitration. So all are the key, I think, you can just read Section 7 in more details to find out. I would request Mr. Sachin, if he's there, or Dr. Shilpa or anyone, to let me know when I have to stop. Because when I'm speaking,
Yes.
Yeah, it's very difficult for I mean, I don't stop checking. So yeah.
So you can continue, sir. No
Yeah.
problem. So students are finding it very interesting. It's being reflected by their questions, and very wonderful reply from your side, sir.
Thank you, sir. Thank you so much. So I'll proceed. So
Yes.
Snehal has asked me another question. Snehal is asking, sir, for international disputes, companies can decide which country is suitable for them. Then don't. It is very difficult for lawyer to know every country's law. Snehal, that's a very good question. The another beauty about arbitration, this brings me to another aspect which I was going to miss, is that you become a global lawyer. When you are an arbitration lawyer, it's not that you will be restricted to the court of India, because you will not be eligible to practice in the courts of that country. But like I said, arbitration is a private setup. So you can go to Singapore, Dubai, US, UK, Geneva, wherever you want, Paris, depending on where your arbitration is seated. So yes, parties can decide the seat of arbitration. Seat is the most crucial aspect of the arbitration. It is the epicenter of an arbitration. The arbitration revolves around the seat. So if in an arbitration agreement you define seat to be, say, London, then the London courts will have jurisdiction for all practical purposes to decide the disputes between the parties. And that is one strong reason why parties are very careful while choosing the seat of arbitration. And they can choose the law also. The applicable law, Snehal is asking me how to prepare for it. So Snehal, they can choose the law of the arbitration. They may say that the law of the Indian Arbitration Act will apply, and the contract will also be governed by the Indian laws. So merely by making a seat or a venue in a foreign country, if they want, they can keep the law of a particular country as the applicable law. And of course, they will choose the lawyers who are familiar with that law to go ahead about it. I hope I've answered your question. Okay, so moving forward. Now, covering briefly the future, because I've told you the importance of arbitration. The future of arbitration, like I said, Mr. Falias Nariman says so, so I completely agree with him. He says that the future of arbitration is bright because future of litigation is not. And it is a very interesting and people are encouraging arbitration as a dispute. And I think in times to come, it will be the first choice, not the second choice. And in my view, it has taken over already. In almost every arbitration, in every agreement that I come across, I don't have to really look at it. I presume that there is an arbitration clause, because as a lawyer, even I advise my clients that, look, we will put an arbitration clause, we will encourage it. So arbitration is gaining a lot of recognition. You can see that a lot of lawyers have in fact shifted their practice from criminal law to arbitration. So the fact that a lot of lawyers are doing it, which makes it clear that there's a lot of work for them. And the idea of being a lawyer, a good lawyer, is to mold yourself as per the needs of the society. And I think in these times, the society, nationally as well as globally, is more inclined towards arbitration, and therefore I feel that arbitration is a very good area of practice for young lawyers like you, and you must consider it as a career option. And the impact of the 2019 amendments, because with time to time, so original act was 1940 act, which was later on the new act which came, the 1996 act, which we follow even today, was amended in 2015 and now recently in 2019. So the 2019 amendments have in fact made it more simple and more clear. The idea is to reduce the interference of the court, and that is what the aim is. And we will have to see how the Arbitration Council of India will function, because that will play a very, very important role in determining the future of arbitration in India. Because the whole idea is to make arbitration institutionalized. Because if you want to make India a hub of arbitration, currently 90% arbitrations are happening ad hoc. Ad hoc means that parties decide everything, arrangements for the hearing, how to go about it, etc., manually doing all that. But like I said, institutional arbitration is more structured, more organized, more convenient, more coordinated, less procedural issues arise because institution takes care of all these issues. And that's why it's always better to do an institutional arbitration rather than doing any ad hoc arbitration. Okay, Divya Nand has asked me a question. How many arbitrators? I told you, Divya, Section 10 of the Arbitration Act says that the number has to be an odd number depending on the amount involved in the dispute. If the amount is small, then obviously we will afford one arbitrator, which is a sole arbitrator. But if the issue is complex and the matter requires three people, it's a vast matter, huge matter involving billions of dollars, then we prefer a three-member tribunal. And again, it has to be an odd number. It can't be an even number. Now, another question from Nitin Pathak. Nitin is saying, at present, Arbitration Council provides some benefits to the lawyers in any way. At present, Arbitration Council. Nitin, your question is not very clear. Can you please explain a little better? I mean, which Arbitration Council are you referring to? Can you clarify? In the meantime, I'll take another question. Osama Iqbal Siddiqui has asked me a question. What is the percentage of parties appealing in the court of law after a complete arbitration? How successful, in your opinion, is arbitration as an alternative to traditional courts in terms of satisfaction of parties? Okay, so Osama, honestly, so I think I have seen most of the parties appealing the award, all dissatisfied parties. So you may say that more than 90% parties appeal the arbitral award and they're not satisfied, of course. One party, obviously, against whom the award is, will not be satisfied. But in terms of, if you compare it with the traditional court system, I feel that most of the times parties are satisfied because it is eventually the claimant whose money is stuck, and claimants are satisfied if they get the award. But only in cases where the arbitrator is biased or there are allegations of independence or impartiality not being there properly, that is the time when the parties are very dissatisfied and they feel that courts are more, genuine and perhaps the veracity. I mean, you cannot question the genuineness of a judge because it's in public, it's all in public, and they trust more in judiciary that ways rather than arbitrators. Nitin is saying, I want to ask that, does Arbitration Council provide any type of benefit? What about, so you talk? So that, okay, that, Nitin, the Arbitration Council of India, it has not come into force as of now. It will be enforced. That has not been notified yet, though it has been introduced in the amendment of 2019, but it has not been implemented so far. Moreover, it will not be giving any benefit to the lawyers as such. It is only a body which will be regulating arbitration in India and regulating and marking the institutions. If you look at the new amendments, they have clarified that Arbitration Council of India will be grading institutions and arbitrators. So that's going to be the limited role of Arbitration Council of India. Okay, so I think I have already crossed my time. I am beyond, I think, sir, do you want me to continue or you want me to now take few more questions and wind up?
Sir, as I attempt to be a learner, a student of you, by asking one question, sir. Will we have any benefit if India goes for having a permanent seat in the permanent court of arbitration? Will it pave some more potential for development of arbitration in India at the international level?
I think you're absolutely right. If something like that happens, then I think it's a very pro-arbitration stance. But honestly telling you, if you look at the BITs also for that matter, the way India has gained a reputation, like honestly speaking, so BIT has been a flop show in India, in my view. I mean, personal view. And so far as the image of Indian courts in arbitration is concerned, if you talk about the international image, though getting a permanent seat there will, of course, be a very positive step. But when Supreme Courts give a message and pass any judgment where they are interfering with foreign awards, like NAFED versus Alimenta, for instance, recent judgment, where the foreign award was not enforced, that's when the international community feels that Indian courts are not taking arbitration, not taking a pro-arbitration stance. So that's how the image of India as a jurisdiction uh, is taken to be a jurisdiction which is not encouraging, and courts are interfering on a daily basis. So parties then refrain from choosing India as a seat of arbitration. So the idea is to give a positive message to the international community by enforcing the foreign awards and by reducing the interference in these foreign awards, and by showing that, look, India is a jurisdiction which encourages arbitration. So you come here, you invest your money here, and we will not interfere with your arbitral awards. You can easily enforce it against these judgment debtors. So that's, in my view, more important than anything else to give a positive message.
Okay, thank you so much, sir, for your wonderful response. And I guess our questions may keep on continuing for the entire day because of your wonderful exposition, sir. But we have to put an end to such sessions, although unwillingly. So at the last,
I think we
uh,
can take three questions. So there are two, three questions. I'll just quickly answer them.
fine.
So
Okay, sir. Okay.
Pratika Priyarshini has asked me a question. Oh, Nikita has asked me a question. Is a career, which one is better, corporate lawyer or arbitration lawyer? See, I am not the right person to answer this because, I mean, arbitration is something I've been doing since day one. So I'll always say arbitration. But believe me, as a lawyer, you are doing everything. I mean, speaking for myself, I do corporate work, I do insolvency, bankruptcy, I do writ petitions, I do bail matters, I do arbitrations. So your specialization may be in a particular field. At the same time, you may practice all areas. So I think that's the beauty of being a lawyer. So it completely depends on your interest. But yes, speaking for myself, I like arbitration more interesting. It's more fascinating than corporate law. So is arbitration a structured solution to cases that are already pending? Won't the vacancy of lawyers and judges increase if the inclination tilts towards arbitration expressly? I think arbitration is a structured solution to a case that is already pending. You're right. But arbitration is a separate mechanism altogether, which provides for a dispute resolution in a time-bound manner. And honestly, it has nothing to do with the vacancy of judges in courts, etc., because courts have no role as such in arbitration. But yes, one thing which you are pointing very rightly, now what has happened is there are original side introduced in courts, and there is a commercial court set up in Delhi High Court and few other courts where there are judges who are only doing arbitration matters. So yes, they are increasing the vacancy of judges, and I think more work for lawyers. So it's a good sign. And eventually these judges who will retire will eventually be arbitrators. So yeah, I think arbitration is in fact creating more vacancy for lawyers and judges. You're right. Okay, Snehil is asking, is it necessary to join firm for arbitration? One can work at individual level. Snehil, you can do it independently. If you are a lawyer, you don't have to necessarily join a firm. As an independent counsel, many people are doing arbitration in courts only. There are lawyers who are only doing arbitration matters in court. They're not practicing arbitration as such, but they're dealing with all court related arbitration, all petitions, and they have a very good practice. And also you can do arbitrations. So first half you finish your court, the next half you do your arbitrations, because the time you can choose as per your own convenience. Okay, Isha Pandey has asked me a question. What information is required before accepting arbitration appointment? So, Isha, when an arbitrator is approached in respect of a dispute, then he has to disclose mandatorily in terms of Section 12. If you read it with Schedule 5 and 7, which were introduced on 23rd October 2015, there are certain grounds of impartiality and independence, which he has to disclose. So the 6th schedule to the Arbitration Act has a format which arbitrator has to disclose. So it's called a disclosure. So he has to say that I will be independent and impartial, and then he will say that I will be able to finish the award within 1 year's time, and I will be able to give sufficient time to the arbitration. Okay, last question is by Osama. Thoughts on online certificate courses on arbitration? Osama, I think it's a great, anything which helps you understand the subject and you can add on to your CV, because the idea is to make an arbitration centric CV. So the moot courts that you are doing, you do on arbitration if you are interested in arbitration. Then like Viz, Vienna Viz, etc., maritime arbitration by NLU Odisha. And you do arbitration internships, then you write research paper on arbitration, you do online certificate courses on arbitration, and you do diploma courses on arbitration, like one ILI has, Indian Law Institute. It's a very good course. So, that's the whole idea. If your CV looks tailored like that, then tomorrow, if you apply in a firm, they will see, yes, this guy is focused, and I think his profile is of an arbitration. So I think that, yes, that way you can perhaps add up to your CV. Thank you, everyone. Thank you, Snehal, Osama, Pratiksha, Isha, Nikita, and all of you have asked amazing questions. I truly enjoyed, and I'd like to over to you, sir.
Yeah, thank you so much, sir, for this wonderful exposition. Now, towards the end, sir, I would like to request Dr. Shilpa Sharma, ma'am, to formally propose a vote of thanks. Over to you, ma'am.
Thank you, sir. Thank you, Dr. Sachin. The roots of all goodness lie in the soil of appreciation. At the outset, I shall sincerely express my gratitude to the speaker for today's webinar, Advocate Tariq Khan, sir, for taking out time from his busy schedule and gracing us with the virtual presence. It was truly a delight to have you with us, though virtually. Your inspiring words of wisdom kept us all in awe of your lively but grounded persona. The students have gained immense knowledge about importance and future of arbitration laws in India, which is immeasurable. The insight received through your lecture will be a key takeaway for all the attendees who are desirous to pursue in this field. I would also like to thank Dr. Sukhvindersinghdari, sir, Director, Symbiosis Law School, Nagpur, whose confidence and wit is inspiring us to thereby weaving positive hopes and aspirations. I extend my gratitude to Dr. Sachin Tripathi, sir, for moderating the session with simplicity and such precision. I am also thankful to IT departments, Amar sir and Rameshwar sir, for their technical support. I will be failing in my duty for not expressing thankfulness to Mr. Ashish Tode, Head of Placement Cell of Symbiosis Law School, Nagpur, for his constant support in organizing such webinars. Lastly, my heartfelt thanks goes to all the attendees across the nation for their curious minds and healthy cooperation. This is Dr. Shilpa Sharma, faculty signing off. I wish you all of you a fruitful weekend. Thank you. Thank you so much.
Thank you, ma'am. Thank you so much. Thank you, everyone.
Thank you, sir. Thank you so much.
Thank you, Advocate.